Started with the first panel. I'm Professor Henry Brown here at the law school, and keeping in line with Susan's point at the beginning, our bios are in the booklet, so you can read all about us there. Rich SALGADO, he is with Google. He's to my immediate right. Paul, you've already met, and Kevin BANKSTON is at the end, and he's going to actually start us off, so I'll let him tell us more about what he does when he starts us off.
So I think my intro slide actually requires a couple of introductions as well. First off, the reason it's yellow rather than red, consistent with CDT's color scheme, is because the red was not visible. We had to change it at the last minute with the lighting scheme. Anyway, you're also probably saying, who is this guy, this free expression guy talking at this privacy thing? That's new. I just started at the Center for Democracy and Technology, moving from the Electronic Frontier Foundation here in San Francisco just at the beginning of this month. And prior to starting my new life as a free expression person at CDT, I spent the last 8.5 years focused primarily on internet privacy and government surveillance at EFF. And so that's the perspective I bring to this particular talk, which is probably going to be my last talk on ECPA for a long, long time. So if you want to tweet, that's my handle if you want to tweet about anything I say. I tweeted Paul's 3 things that he tells to his students, which I thought were all very apt. And I'm particularly glad at this point of the fact that ECPA is resistant to human memory, because some of the things I'm going to be saying are repeating and clarifying some of the things he said. I hope that will help it stick in your brain. So we're here to talk about cloud. We're here to talk about content. Let's start with email. I mean, we all have it. We all use it. And you'd think that considering Congress was thinking specifically of email back in 1986 when it wrote ECPA, that there would be some really clear, sensible rules that make perfect sense when it comes to email. You might think that, but you'd be wrong. You'd be horribly, horribly wrong. Yes, there is a basic rule. There is a basic rule. Email requires a warrant. That sounds very nice. It's not actually really the basic rule, or rather there are so many exceptions to it that you can drive a truck through it. Those were out of order, apparently. The biggest one being this 180-day rule. ECPA, or rather the Stored Communications Act portion of ECPA, the SCA, protects emails in storage for 180 days or less with a warrant requirement. It's more complex, and we'll get to that. But after 180 days, it can be obtained with only a subpoena. You're probably wondering, why is this the case? As Paul sort of touched on, it's based on the way email worked in 1986. Back in 1986, if you were one of those weird, geeky, odd people or scientists who had, often the same people, who had email, you were probably dialing into your university system or a bulletin board system and pulling down your email and deleting it off the server as you did so. There would not be then any email on the server after 6 months. If there were, that meant you'd probably abandon the account. But there probably wouldn't be anyway, because even if you left it on the account, hard drive space was actually expensive back then rather than being cheap as borscht, and they probably would have deleted it for you before 6 months happened. So that's why we have this 180-day rule from 1986, but now we live in a world where we're keeping years upon years of email in accounts with folks like Google or Yahoo or Microsoft, and it doesn't really make sense anymore if it ever did. And notably, I've never heard any articulate explanation from anyone in government as to why this rule should continue to be the rule, other than simply it's the way it is and it makes our life easier, so, you know, deal with it. I don't actually think that's an adequate explanation. But anyway, to the extent you want to follow along about how the statute works, on your USB key is the text of 18 U.S.C. 2703, which is the main statutory section we're talking about. There are also key definitions in 2510 and 2711. So there's also the opened unopened rule, and I put it in quotation marks because I think it's incorrect, as does the Ninth Circuit, but basically the DOJ says that if you've opened an email, if you've already downloaded it, it's not protected by the warrant requirement. And in fact, this logic extends to your sent email folder and your draft email folder. The basic rationale is ECPA only requires a warrant for communications in electronic storage with an electronic communication service provider. And we won't get deep into what those definitions are, but the DOJ argument is once you have opened the email, or prior to having sent it, in the draft folder, or after having sent it in the sent folder, you've already availed yourself of the communications functionality, and now you're simply using the provider as storage, which means the provider is providing remote computing service, another bizarre term in ECPA, and material, even content stored with an RCS is obtainable with only a subpoena. So, I mean, what is the upshot of this rule? Can someone tell me what's the most protected folder of mail in your email account? Preferably a student, not an ECPA practitioner or a law professor. Someone want to hazard a guess? What is the most strongly protected email box you have under law? Your spam folder. Your spam folder requires a warrant. Everything else can be gotten for a song, otherwise known as a subpoena. So your spam folder is very well protected. Everything else, not so much. Notably, this opened unopened rule, as Paul indicated, has been rejected in the Ninth Circuit in a case called Theophel v. Ferry Jones. Luckily, for those of us who care about the privacy of our email, most email providers, AOL being a key exception, are in the Ninth Circuit. Problematically, however, the DOJ has been known to go to courts outside of the Ninth Circuit to obtain ECPA orders, SCA orders, non-warrant D orders, 2703D orders, to try and get email out of the Ninth Circuit, getting around this decision. Thanks a lot, USA Patriot Act. As Paul indicated, a lot of the Patriot Act was really not about foreign intelligence, but was about amending ECPA and its garden variety criminal law enforcement rules. One of them was you can now use ECPA orders from around the country to get email in other parts of the country. So how often do they do that? How often do they route around Theophel v. Ferry Jones? How often do they obtain email based on this open unopened theory? How often do they use ECPA at all to get your email? We don't really know, which is a problem. We don't really have any idea, and part of the reason we don't have any idea is because of the secrecy surrounding this process. The government goes to a magistrate like Judge Smith. Far too often, Judge Smith being one of the exceptions, they simply sign off on whatever's put in front of them, and it's often there is no notice. Sometimes even when notice is required, like in the Warshok case, the person doesn't get it when they were supposed to. And so you have this problem where we don't know how often this power is being used. There's no comprehensive reporting about it. There's inadequate notice. There's no statutory suppression remedy, so it's not litigated often enough. And what you get is a cycle whereby the government can, for years at a time, get away with really egregiously aggressive legal theories and obtain powers under ECPA that Congress probably never intended and that may be unconstitutional, without anyone even knowing about it. This is what happened in the case of warrantless cell phone tracking. We had assumed they were getting warrants because there seemed no other authority for it until Judge Smith and Judge Orenstein published their first opinions on the issue in 2005. Thank you so much for doing that. If you want to read more about this particular secrecy and accountability problem, you can check out the paper I wrote for the last ECPA Symposium that Susan put together. And she was very good at dogging me to actually write something, and I will always be thankful that she did. Unclear whether I'll be writing something this time, but you know, new job and all, but we'll see. There's a related problem to this secrecy and problem to the extent that in the rare cases where we do get a window into what's happening, whether because a judge like Judge Smith publishes an opinion or a company is able to get a controversy unsealed so we can jump in and get involved, when we win, the government typically won't appeal because they are afraid of appellate guidance on these issues that goes the wrong way. Well, one notable example of this is cell phone tracking. There have been over a dozen, I think perhaps 2 dozen decisions by magistrates and district courts saying you need a warrant to track a cell phone. They have not appealed any of those to the appellate courts. Another example is this case. In 2010, summer of 2010, Yahoo was able to get unsealed a government attempt to get a D order in Colorado to go into the Ninth Circuit. Well, actually, to go into the Ninth Circuit and get email with a D order without a warrant. And Yahoo was able to get that unsealed so EFF could come in as amici, joined by Google, joined by Paul, joined by CDT, arguing, hey, dude, that's unconstitutional. And we didn't call it court, dude, I'm sorry. We filed a brief. It's a very good brief, I'd say. And the government goes, oh, actually, we don't need that anymore. We're going to withdraw our request. So there's a pattern of them not appealing. There's also a pattern of them dropping their applications when there's pushback. This is the third time this has happened to EFF. We were invited twice by a magistrate in New York, Judge Dolinger, when the government attempted to get D orders from him for opened email without a warrant. And each time we were allowed to come in as amicus, the government suddenly decided, you know, actually, we don't have an investigative need for that anymore. It is a win. We protected privacy in this case, but ultimately, in terms of accountability, it is a loss. So this is a win. This is a real win. US v. Warshok was mentioned before. Stephen Warshok, you may know him as the proprietor of the company that provides Enzyte natural male enhancement, which you've probably seen late night cable ads for. He was prosecuted for a variety of types of fraud. They used subpoenas and D orders to get hundreds of thousands of his emails. He brought a case against the government where we got a great decision from the Sixth Circuit finding that his Fourth Amendment rights had been violated, but then the en banc panel said, actually, it's not ripe anymore. So that went away, but then when he was finally went to trial and prosecuted and convicted on appeal, we got a great ruling that, yes, his email was protected by the Fourth Amendment, and they'd violated the Fourth Amendment, as Susan and Paul made clear. And I think US v. Warshok is particularly useful because it highlights the role of analogy when considering how to apply the law to new technologies. You know, when you're applying the law to new technologies, the analogy is key. And I put the metaphor as key simply because that's the title of a great article by Professor Frumkin on encryption that everyone should read. But really, I'm talking about analogies. And the government says these are the right analogies. Bank records and dial digits, coming off of the US v. Miller case and the Smith v. Maryland case that Paul and Susan mentioned. But we and Warshok put forward some other analogies that we thought are better and that the court cottoned to. There's your mail, although it's not the best analogy because your mail's in an envelope. You know, the mailman can't read your mail because it's in an envelope. The government would say the better analogy there is actually a postcard, which the mailman can read. But then you look at your phone calls. The phone company can listen to your phone calls and, in fact, has for a long time had a legal allowance to do so when necessary to provide service or combat fraud, and yet the Supreme Court found that it was protected by the Fourth Amendment. And the highlighted one is my favorite, actually. Analogy to rental spaces, where you still maintain a reasonable expectation of privacy. I'm in a hotel room right now. Thank you, USF, the Sir Francis Drake. And there is a cleaning staff that comes into my private room and cleans it, provides an agreed-upon service. You know, they left me some nuts. It was very nice. And yet, if the government wanted to come into my hotel room, it would need a warrant, even though I have voluntarily exposed my hotel room to that staff, even though I've arguably assumed the risk that they're going to tell the government something about what's in there. I think that's a really great analogy for what we're talking about today, the cloud. I'm basically renting, either directly or through giving them my eyeballs for ads, a space online to store my stuff. And I might let them into that account to clean it out of spam and viruses, or to, instead of leaving me nuts, provide me a targeted advertisement based on the content of my emails. And yet, I still have an expectation of privacy there. And the Sixth Circuit agreed, and that's great. So what's happening now? What is the government doing in this area? what we've heard anecdotally, I hope and expect is true, and we can ask the panel later, is that the DOJ's official guidance is to follow Warshok across the country. Companies like Google are certainly following Warshok and using it to push back to the extent anyone's asking for stuff without a warrant, and that's a good thing. Notably, the government did not seek en banc review or cert on Warshok, which I think highlights how good they think they do there. I think the Jones decision highlights just how poorly they probably would do at this point. But there are still a lot of open questions about how ECPA and the Fourth Amendment apply to things other than email. Email's the easy case. What about other data in the cloud, like something stored with Dropbox or my Google Calendar, or other things where I don't necessarily communicate, I simply store? I think the ECPA argument there is you're actually using an RCS rather than an ECS in that case, and all of that can be gotten with only a subpoena, which is a problem. Electronic communication service, where if I store it with an ECS, it requires a warrant prior to 180 days, or if not opened according to DOJ. RCS is a remote computing service. It means a service that provides storage or processing of your data as opposed to providing a communication service. And that only requires a subpoena under current ECPA. There are open questions about how the law applies to your clickstream data. If someone is logging where you're going online, how does the law protect that? Search logs is a great example. There was a lawsuit. The government was defending the constitutionality of an online porn law, and they went to Google with a discovery subpoena to try and get logs, search logs, indicating how prevalent porn was online and how popular it was. And the response was really interesting. Google said, we think this might be protected by the ECPA, by SCA, such that if we provide the stuff, we might be liable, and that's a burden to us, so don't make us do that. CDT put in a great brief that argued that this was, search logs were in remote computing storage because you're providing these queries to the company to process them and send something back to you, which would also prevent civil discovery. Susan ringlet, it was you, right? Ringlet a brief that basically said, stay the heck away from this issue. It wasn't you. Okay, there was a group of professors. Oh, you signed it. There was a group of professors that filed a brief that said, this is a really hard question, you should just stay the heck away from it. And then the government said, this isn't protected by the SCA at all, period. So that's still up for grabs. There's cell phone location info which will come up, IP addresses. What are the right analogies for these things? How does the law apply to them? How should the law apply to them? DDP has an answer. DDP thinks that we need to update ECPA such that any content, which in the statute is currently broadly defined and should remain defined as any information concerning the substance, purport, or meaning of your communication, should require a warrant regardless of how old it is, regardless of whether it's ECS or RCS, regardless of whether it's open and unopened, and regardless of whether or not the company accesses it to provide you other services. So Jim will be talking more about that in the keynote. Jim Dempsey of CDT, who's been the ringleader of that DDP, Digital Due Process for Reform effort. But clearly there is still a lot of work to do in the courts and the Congress, and it's a really fun area to be in. I hope students here today will look at this as a great area to write papers or articles on, because there's an enormous amount of fascinating, interesting issues that need smart people analyzing them. So on that note, taken probably far too much time. So I'll sit down.
And Kevin, before you sit down, actually, the thing that makes sense, since each of the panelists are speaking on slightly different issues, that we give you a few minutes for questions after your topic. Okay. And I actually would like to ask the first one, if I may. If we start with the premise of reasonable expectation of privacy, and I operate on the internet, and I operate on the cloud, and I don't trust it, I don't actually expect that my information be privacy. How do we define privacy in the context where I may not historically expect it to be because of the nature of how I'm interacting with it? Because when I put that stuff up there, I don't know that I believe that I'm going to have privacy. Is that?
I mean, I'm not sure we should come up with rules based on what you expect.
Well,
but,
understood.
I mean, I think that one of the ways we can think about this is by looking to how people actually treat the technology. One of the arguments made in the Google case, a point that was made by the judge in the Google case, was the prevalence of searches for pornography on Google are pretty indicative of the fact that people expect that to be private. because we usually don't go around advertising our interest in pornography. I think the fact that people store private things in the cloud via a Dropbox, or the fact that they engage in communications on incredibly sensitive topics via email, are indicative of the fact that society expects this to remain private, even if the architecture doesn't necessarily guarantee that it's private. And I think that's probably what we should start looking to. And I think that the Jones decision provides a lot of promise here, because 5 of the justices, those on the Alito opinion, and Judge Sotomayor, who agreed with it, they found an expectation of privacy, to some extent at least, in information that was exposed to the public. Even though you were walking around in public, you still somehow have some expectation of privacy that was violated by this GPS tracking. And I think that indicates a potential that we are moving away from a mechanical application of this assumption of risk doctrine that has so often been used to find that we don't have any privacy, even though we all clearly are expecting privacy.
Questions?
All right.
Can I ask Kevin a question?
Absolutely.
So, and this is partly because I mean, maybe this is, let me just throw this out there. So the one thing that's always troubled me about Warshok and cases like that is we've got this rich body of separate case law dealing with subpoenas, right? And subpoenas are just funny pieces of paper that compel someone under penalty of whatever the judge wants to do to them to produce documents in their possession. And as I recall the initial Warshok opinion said, you know, subpoenas usually kind of trump reasonable expectation of privacy considerations, even with third parties. And if you can require notice, I hope I'm not losing the audience, if you can require notice plus a subpoena, that might be enough for the Constitution. If you give them the opportunity to come to court and argue why it doesn't satisfy the subpoena standard, that might be enough. And I don't remember that getting a lot of play in the second Warshok opinion.
It didn't really come up, but I mean,
Yeah, but what's the response then? I'm just.
You should have read our briefs, because that was actually basically our position, which is,
Yeah.
to the extent you have notice that the government is subpoenaing your stuff,
Right.
it's analogous to them subpoenaing you directly. You have an opportunity to go to court, to challenge it, to say it's overbroad, to say that what they're seeking isn't relevant, to say that what they're seeking is privileged.
Right.
The concern is when they come after it without notice. And then, even though the DOJ would say it's a compelled disclosure, which should only be judged under the reasonableness rules that apply to subpoenas, because you don't know about it constructively, it's a search or seizure of your stuff. I mean, assuming that you do have an expectation of privacy in it, if they come after it and you have no knowledge of it, no opportunity to stop it, it's much more like a search or seizure, and I would say is a search or seizure, and not a compelled disclosure.
But say you're right, so in the context of the argument you're making in your brief, then we might not need probable cause.
Well, but
We
that
have
was
this whole
before the
other set
Warshok
of-
decision.
I know, I
And,
understand, yeah.
and notably the decision in the Third Circuit on cell phone location information, which will be discussed later, which did say, to the extent this stuff has a reasonable expectation of privacy, warrant is required with no mention of this notice thing. So I would say that we have now developed some precedent in the Third and the Sixth Circuit that could point to, even if there is notice, it still requires a warrant.
other
But
circuits-
that could lead to a fairly weird
Yeah.
and weird disjunction where if I store it in the cloud, it's actually more protected than if I keep
Right.
it in my house,
Right.
which would be an admittedly odd result.
Right.
But I want to jump in here and say you should have read.
Susan has strong opinions on this
I
issue.
want to jump in and say you should have read our brief. The law
I've got a
professor
lot of
brief.
things to read. I probably did read all these briefs.
And
but maybe it's just
Trish-
my memory.
Resistant to
generally.
memory.
Yeah.
Trisha Belia and I wrote both a brief and a paper in Chicago Legal Forum arguing that it doesn't make sense that even if notice is provided, you've waived an argument about reasonable expectations of privacy in the information. If it's confidential information, when did you waive your reasonable expectation of privacy Fourth Amendment argument, says us. And also, if you look at the district court decision in Warshok, she explicitly said, we're going to give, we're going to give you notice and a hearing so you have an opportunity to raise whatever arguments you have, including arguments about a Fourth Amendment interest. So I think it's an open question and an interesting one.
Okay.
Which is a good segue. Most of us use Google and other search engines, and the information isn't being sought from us, it's being sought from Google, because they're the ones who store it. So then the question comes to Richard, which is, what do they do when the information is requested from them?
Well, I'll take the stand. I think I've got a slide here we'll throw up. So good morning. Just by way of introduction, I'm Richard Salgado. I'm director at Google and handle law enforcement, government demands for user data, and also some of the network security issues. And before that, I was with Yahoo doing the same thing, and before that, Paul and I were together at the Computer Crime and Intellectual Property section in Washington as prosecutors. And I'll say, it's one thing to rip through ECPA and read some cases and try to understand kind of academically how it works. And it's another to be working in a company that gets lots of legal process and actually have to struggle with this thing every day and get legal process handled responsibly at a very high volumes with short deadlines. So my complaints about ECPA are not just in quote marks around the shortcomings that it has around privacy, but also the complications of it actually make it difficult to handle legal process in a responsible way. We've been at Google trying to address this in a couple ways. First of all, we've got a team of people who deal with legal process. They're trained, they're professionals at this. We've got lots of them because we have lots of legal process. As a general matter, kind of to talk to some of the points that, Kevin, that you've heard earlier today, it's Google's position, first of all, on notice, that it's important that users get notice when their information is being requested from Google. And we try to give users notice when that happens. We're not in a good position, and really very few providers would be in a good position, to know all the different potential objections that a user might be able to make in response to a legal process. There may be attorney-client privilege, doctor right, all these privilege issues, we have no idea. We just know that this is sexyboy101@gmail.com and the information is being requested. That's it, right? And this is one of many, many subpoenas that we would have gotten in that day. So we're not well positioned to figure out, is there something here that's weird, or is this just a run-of-the-mill subpoena? Is this somebody who's engaged in phishing and really ought to be investigated and prosecuted, or is there something else a little bit different about this and the user ought to have an opportunity to fight it? So our preference is to give notice when we can give notice, recognizing, of course, that there are lots of situations where nobody in this room would really want the person to get notice, that there are lots of legitimate law enforcement investigations, and you don't want to screw up an investigation into a child pornography ring in order to give notice for the user to be able to defend against it necessarily. So we do rely on the legal process to be able to navigate kind of the balancing there between jeopardizing investigations and giving the user an opportunity to oppose the legal process. But it is our preference to give notice when we can. And we do note that most of the time, government entities have an opportunity to go before a judge to be able to get a gag order and have it heard. So those are the kinds of things that a provider can do to help put a little bit of robust control over legal process that gets to it, so that the people who know whether there is something to object to have an opportunity to do so. I should also say, as far as search warrants and content go, Google, and I think a lot of providers are taking this position, sees the Fourth Amendment, particularly as it has been applied in the Warshok case, but in other cases, as establishing that there is a reasonable expectation of privacy such that disclosure of the contents held with the third party is protected by the Fourth Amendment. And not limited to email, but other material that is uploaded to the service provider to be handled by the service provider. So you hear a lot under ECPA about electronic communication service, ECS, and remote computing service, RCS, and the crazy rules that apply in the 180-day rule. I think most providers now, although I really should only speak to Google, view the way the case law is going, and certainly viewing the Fourth Amendment, as applying to any content that is provided by the user to the service. So that for Google would include things like calendar and docs and all those others, even where there's not a communication function going on, that there's not another party involved in the doc that you're uploading, the notes that you're keeping for yourself. It's still material that you've put with the service provider as part of the service that the company, in this case Google, is holding on your behalf. It's our view that that is protected by the Fourth Amendment, and unless one of the exceptions to the warrant requirement apply, that's not to be disclosed to a government entity as a matter of compulsion. Yeah.
Where to search
Search is one where we take a pretty hard stance, the same with other material. So we view search as it's provided to us the way other information is provided to us. So, and that, which is very consistent with the litigation that Google was in with the Department of Justice back in 2006. So we take this stuff very seriously. So there's a couple things we're doing. I mean, other than we